Hello, everybody. Thank you so much for joining Glynne and I. My name is Soila. I'm the founding editor of the divorcemagazine.co.uk. It's an online magazine all about divorce and separation, and focusing on divorce law UK and other divorce law for that matter, and financial issues, helping children cope with divorce. There's a lot of information on there, so please do visit, and you'll find a lot of what you're looking for will be on the divorcemagazine.co.uk. And also don't forget to subscribe on our YouTube channel. We have videos coming on all the time, so you'll be kept up to date with what is coming up next. If you have any questions that are not covered, just email me, soila@thedivorcemagazine.co.uk, and I will take it from there. So Glynne, hi Glynne, thanks so much for coming.
Pleasure.
I'll let you introduce yourself and you can tell us what it is that you do, Glynne.
Okay. Obviously, my name is Glynne. I'm a family mediator and have been a family mediator since 2003 and have been a qualified and recognised legal aid family mediator since 2005. Currently, I provide family mediation for Oliver Fisher Solicitors in Notting Hill. I also provide supervision as a PPC for South Essex Mediation in Basildon, and I also run a private practice from my home, which is in Harlow in Essex.
Okay. So today, the reason why I actually contacted Glynne, I'm just telling the listeners, was because we've had quite a few questions on the divorcemagazine.co.uk coming in about legal aid and family mediation, and there have been changes recently about the whole setup of legal aid and family mediation as well, and I think it's still an ongoing process. So Glynne, what I would like to ask you is legal aid still available for family mediation?
Yes, legal aid is available for family mediation. It is not subject to any domestic abuse criteria. It is simply a question of whether somebody is financially eligible for legal aid, and obviously the matter that they wish to discuss has to fall within the remit of what would otherwise be a court application. But subject to those criteria being satisfied, legal aid is available.
So what if we look at the financial side of it, at what point does somebody become eligible for legal aid?
There are two thresholds that have to be satisfied. The first is a capital threshold, and that will take into account the value of the equity in the family home. It will also take into account any savings or any other valuable possessions that someone owns. The limits depend on whether or not it's financial mediation that is required or child only, and there are quite generous allowances for subject matter of dispute, and there are generous allowances for a mortgage. So although it's impossible to give a concrete figure, you have to have a reasonably valuable family home in order not to qualify for public funding. But of course, that can be geographical, because if you live in central London, the likelihood is that your family home is going to be worth a lot more than it will be in the provinces, and therefore more people fall foul of that capital threshold. That capital threshold in London than they do elsewhere. The limit of disposable capital is £8,000, having taken into account all the allowances. If you pass that capital threshold, then you go on to look at the income threshold. If you're on what's called a passported benefit, which is income-related job seekers allowance, ESA or guaranteed pension credit, then, provided you've passed the capital threshold, you are passported through and will automatically be eligible for legal aid. If you are not on a passporting benefit, then there needs to be a calculation done of your gross monthly income, any allowances that you might have that can be deducted from that, such as housing costs, children's dependent allowances, and the magical figure that you're looking for is £733 at the end of that.
Okay.
It's also worth saying that when you look at the income threshold, your gross income from all sources is over £2,657 per month, then you won't be able to go any further. You'll have fallen at that threshold.
Okay, so is it possible to not pass the capital threshold but still be considered within the the income threshold or not?
No, it's not. A few years ago, it was. A few years ago, we had a bit more flexibility in that we didn't have to look at that capital threshold in the same way that lawyers always had to. But the law changed, so now I'm afraid the capital threshold is the first one that has to be taken into account.
Okay. And does that include, I mean, you mentioned property. Does it include cars? Pensions, would that come into capital or income, or is that not?
No, it mainly is looking at what are realisable assets that have a fixed value as opposed to something like a car. I would imagine the legal aid agency, if you were driving around in, I don't know, this year's Lamborghini, the legal aid agency might question that under valuable possessions because clearly there would be a worth to that. But if you're driving around in a 3-year-old Fiesta, that's unlikely to be the significant factor in taking you over the threshold.
Okay. And does legal aid cover both financial issues and children issues, or is it just financial issues?
No, it covers both aspects. It covers anything that could be made an application to the court under a family law remit.
Okay. This might sound like a really bizarre question, Glynne, but what does legal aid actually mean? What does it stand for?
For the purposes of mediation, it covers all costs that would be associated with the mediation process. We get a pot of money from the legal aid agency, and that covers the MIAM. It also covers the mediation sessions, and it also covers the preparation of documents as an outcome of that mediation. Now, clearly, it's a finite pot of money, so although we're not restricted in the number of sessions that we can provide, we are obviously going to be aware of the fact that if we provide 6, 7 or 8 sessions of mediation, we will be losing money. So most services will try hard to keep within the amount that will make the finite pot of money at least break even, if not give us some sort of profit. And we need to cover our costs.
Is that relative as to how many number of sessions? Like if you do legally aided family mediation, yes. I do it. Well, if I did it, would it mean the same for both of us in terms of how many sessions we would give per couple? So yeah.
There are different amounts of money available, and if you're looking at mediation on children's issues, you get a certain amount of money that tends to cover roughly 2, possibly 3 sessions of mediation. If you're doing financial and property or all issues mediation, you get a larger amount of money to reflect the fact that it takes more time, and that generally covers 4 to 5 sessions of mediation.
Okay. And you mentioned the MIAMS.
Yes.
If you could just tell us exactly what a MIAMS is.
Yes, I think if I could. Someone might.
As soon as I asked that question, I thought, okay.
I can tell you what it stands for, yes. And I can tell you what it's supposed to do. There's a fair amount of controversy at the moment about how it works and who can deliver it, but the bog standard facts are that the MIAM stands for a Mediation, Information and Assessment Meeting. It's the first stage in any family mediation process, and it's an opportunity for the party and participant and the mediator to discuss the suitability of mediation, to discuss the willingness of the participant to mediate, and to have a dialogue about whether or not it's going to be helpful. Okay. It has another role in that it's part of the pre-court protocol. which means that if somebody wants to make an application to the court, they have to attend that MIAM. At that point, there's some blurring of the definitions, and it becomes what's known as a statutory MIAM, because it's required, as I say, by statute under the pre-court protocol. And if that's what's required, the mediator who conducts the MIAM provides a signature on the appropriate court form to confirm that the person attended that meeting. But most mediators would say that that's a byproduct of what they're delivering. Most family mediators will say it's a vital introductory meeting to explore the parameters of mediation and for everyone to make a determination as to whether it's going to be helpful.
Okay, all right. And if somebody was going to come in for a MIAMS, for example, I'll ask you the same question with regards to legal aid, but what do they need to bring with them? Do they need to bring anything? Any documents, papers?
Yes, they do. In order to qualify for legal aid, the mediator needs to complete a form that's called a Civ Means 7 form. If anyone wants to look at it, it can be downloaded as a PDF. It's not a private document. And on that, the mediator will go through the process, looking at capital threshold and income threshold. At the moment, there is no requirement for the applicant to bring in a formal valuation of the family home. So for the capital threshold, for the valuation of the family home, we take the word of the client. However, if you're talking about capital savings, we do ask to see the capital savings amount, the book, the Abbey National book or whatever it is to show, or your ISA to show what's in there.
Okay.
My understanding is the reason for that is that the amount in an ISA is what it is, whereas a valuation of a family home can depend on the estate agent and the market. So I think what we're looking at is figures that can be accurately determined. Then looking at the income and the evidence required, the evidence required will be if someone is on a passported benefit, they will need to bring in the award letter that says categorically that the benefit is income-based, income-related. Okay. If that letter is over 6 months old, they will also need to bring in an updating bank statement that shows that that payment is still going in. Okay. Most mediators will ask for a bank statement going back 4 weeks anyway, just to cover their backs. It looks at income from all sources, so it will also look, if it's not apparent on the bank statement, we will also require to see any tax credit awards, any child benefit, and obviously if they're earning, any wage slips.
Okay. And that's all. That's the documents that they need to bring in for a MIAMS, and you only need to go for the MIAMS if you're planning to go through court.
You only need to go through a MIAM if you're planning to go to court, because the whole process of mediation is voluntary.
Yes.
However, if you want to mediate, you will also be required to attend a MIAM as part of the mediation process, but that's not a mandatory requirement. Okay. It's just part of the process. Does that make sense?
It does make sense. What I just found myself wondering, and I don't want to stick so much on the MIAMS bit, but I just found myself wondering because I volunteer with Wandsworth Mediation Services. And sometimes after a couple of sessions, we realize that actually one of the clients is coming in because what they're actually looking for is a MIAMS. Yes. Now, once you're in the process of mediating with a couple and you realize this, you can then go back and do a MIAMS for their sake if this is what they're looking for. So it's kind of like in reverse order. It's not the first meeting where you do your MIAMS and then send them off, but you can be mediating with them. Then they say, I want to go to court. Then you do a MIAMS.
Right. This is where I think probably the terminology becomes more confusing than it should. The mediation is an unregulated profession. However, we are, as a profession, trying hard to self-regulate. And as part of that process, we agree to operate under a code of practice, which is published by the Family Mediation Council. The Family Mediation Council's code of practice stipulates that before any mediation takes place, a MIAMS or information meeting should take place. Now, because we're unregulated, there is nothing that would prevent a member of the public attending for a mediation, information and assessment meeting with a mediator who cannot sign off a statutory MIAM. However, there is going to be that risk that if it goes along to mediation and mediation breaks down, that mediator would not be in a position to sign off the formal MIAM to allow them to go to court.
Yeah. But you have to take the word of the client when they come in first, that they're just coming in for regular mediation. Have you ever experienced that, where you have clients who come in for mediation and then at some point, 2 sessions through, you know, one of them says, but all I want is a form to say that I've come for mediation because I'm planning on going on to court. Then you're caught in a place where it's, you know.
Yeah. I mean, if you follow the code of practice, that should never happen. Because if you follow the code of practice, you will have explored the motivations of the client at that information meeting. And, you know, you will have asked them at that point whether or not they want actual mediation, whether they are coming in for the statutory signature. It shouldn't be an issue. Obviously, you're only in control of so much, and it's possible, and it does happen, that if mediation breaks down, even if you followed all of those sequences in the right order, then the client will want a signature.
So it's really important for clients to be as open and as honest as possible when they come in initially, because if it then unravels later, that's something that their intentions were different from what they purported when they came in. It can, yeah.
It is, but I think the responsibility lies firmly with the mediator on that issue, because the client doesn't necessarily know at that point. You know, people are coming in a distressing time in their lives, not quite sure. They know that they want help. They're not quite sure what help they want or how they can access it. And I think the client can only be as honest as they feel on the day. I think it's quite common for somebody to come in and feel that they do actively want mediation, because in their head what they want is resolution and closure, and they see mediation as a means to getting it. But if they start the process and it becomes obvious that in fact mediation is no longer going to be helpful, then I think that's a risk that you take. But I firmly think that it's the duty of the mediator to explore that as fully as possible with the client at that information meeting to minimise that risk.
What if a couple comes to you and only one of them is eligible for legal aid? How does that work?
As long as the eligible person comes in first, so that when you see the second person for a MIAM or an information meeting, you already know that one person is eligible. Or if they come in together and you assess the first person as eligible, then the other person gets the MIAM or the information meeting totally free of charge, and he or she also gets the first session totally free of charge. And that can be extremely helpful when talking about children's issues, arrangements for the children, because although most financial or all issues mediations takes several sessions, it's quite common for children's issues mediation to be resolved or largely resolved in that first session. So you could end up with a person that's not eligible. They could, you know, to all intents and purposes, they could be a multimillionaire. They would still qualify for that free first session. And that could mean that both parties would have free mediation that could possibly resolve in that first session. A big caveat that that's relating to children's issues only.
Right.
I think there is a risk that people can be lured into a mediation process hoping that a complicated financial settlement can be sorted out in one free session, and that sets up everybody to fail, because that's not going to happen.
Yeah. So what if it's financial issues and only one person is eligible for legal aid?
In that case, they still get the first session funded, but the role of the mediator would be to explain clearly that the likelihood is that for mediation to succeed, you'd be looking at 3, 4, 5 sessions of mediation, and there would be an expectation that it's not an expectation, it would have to happen, that the non-eligible person would pay for session 2, 3, 4, and the outcome documents.
Okay, all right. And for somebody coming in, what proof do they need to bring to show that they are eligible for legal aid?
Well, apart from the documents that I mentioned, so I've mentioned before the wage slip, the bank statements, I've mentioned any award letters that they've got. If they want to take off any allowances, there are more complicated criteria. So, for example, if your rent or your housing costs are more than a third of your gross income, you need to bring evidence of that. If you don't have dependent children, your deduction is capped for housing costs at £545. And I always say to people, if they've got quite significant childcare costs, to bring those in as evidence on file so that we have a full set of supporting documentation to evidence their eligibility. The reason for that is obviously we're dealing with public money. Obviously we have a responsibility to the legal aid agency. And apart from anything else, the legal aid agency regularly audits legal aid mediation services. And one of the things that they're looking at is that we have a robust system of assessing eligibility and that we have the evidence on file to show that.
Okay. Thank you so much, Glynne. Thank you very, very much. Really informative, the whole legal aid and family mediation and how it works. If anybody wanted to contact you, how can they go about it?
Yeah, I think they can, if they're living in London and they want to contact me through Oliver Fisher Solicitors, then it's going to be glynne@oliverfisher.co.uk. If they wanted to contact me at South Essex Mediation Service, my mind has gone blank. I've got no idea what the email address is, but if you look up South Essex Family Mediation Service, there will be a link. And privately, the easiest one is my own email address, which is email@glynne, glynne-davis, davies.org.uk.
Brilliant. Thank you so much, Glynne. That was brilliant. Thank you so much.
My pleasure.
Take care.
You too. Thank you. Bye now.
Bye-bye.